Good afternoon, everyone, and welcome to today's webinar titled U.S. Aerospace and Defense Market Entry, Proven Strategies for Success. My name is Shafak Erdem, and I will be your moderator today. I'm a managing partner at Herdem Attorneys, where we provide legal guidance to businesses operating across highly regulated industries, including aerospace and the defense. Our discussion today will focus on how companies can successfully navigate the U.S. aerospace and the defense market, overcome regulatory challenges, and adopt strategies that have proven successful in this competitive space. We are fortunate to have two distinguished experts who are joining us today for this interesting conversation. Please welcome Mr. Anthony Raba and Brad Henry. Being Anthony and Brad as one of the partners from Blank Rome, and I would like to suggest if you can introduce yourself briefly, mentioning your expertise, and let's start with Brad.
Hi, thank you, Shafak. Good morning and good afternoon to everyone. I'm a partner at Blank Rome, or an AmLaw 100 firm in the U.S. We specialize, Anthony and I, in white-collar criminal defense, government investigations, government contracting, international trade, which includes, of course, work for the defense industry, which brings us to our conversation today. Anthony?
Yes, thank you. So Anthony Rappa, I am the co-chair of the International Trade Group at Blank Rome, I'm based in Washington, D.C. My practice and the practice within our group focuses on every area of international risk, including export control, trade control, national security, foreign investment review. And as Brad mentioned, that includes extensive experience with the aerospace and defense industry. So looking forward to the discussion today.
Perfect, great. Thank you, Brad and Anthony. Now let's dive into our discussion on regulatory challenges and the market entry first, and then we keep moving forward in other areas. So my first question is, what are the most critical regulatory frameworks that companies need to navigate when entering the U.S. aerospace and defense market, particularly regarding export controls and the sanction side?
Yes, well, maybe I could start with that because there are several. And first and foremost, what we would put at the top of that list for any company that is looking to enter the U.S. aerospace and defense market is the International Traffic in Arms Regulations, ITAR, ITAR. This is a term that you will hear all the time. It's probably a term that many of you in the audience have heard already. And this has to do with the U.S. regulation of the export of defense articles and the export of technical data relating to defense articles, and also providing what we call defense services to foreign persons. So I put this at the top of the list because any company that's going to be engaging in defense work in the United States is either going to be receiving this kind of sensitive technical material that is regulated by the ITAR, or this is going to be a company that is involved in manufacturing or generating this type of regulated material or equipment. Or munitions. So for those reasons, we put that at the top, because to even be able to begin to manufacture any defense articles in the United States, as a starting point, you have to register with the U.S. Department of State. And we can get into some of these details during our discussion today, but just, as a headline for our discussion, to enter the defense market, ITAR compliance is at the top of the list. And what that involves is registering with the U.S. Department of State, which is hopefully is a short approval process to do that, but first they have to approve. And by registering, you get the standing to engage in that type of activity in the US. You get the standing to go to the State Department to get export licenses or to do other stuff that you need to do in the defense market. And also, many customers in the US, whether it's the government agencies directly, the Defense Department, or the major prime contractors in the United States, are going to look to see, are you ready to comply with the ITAR? Or if you have a US business and you're looking to incorporate in the United States or have a subsidiary, are you registered with the ITAR? So many companies will not do business with another company in the industry unless either they're registered or at least they have a compliance policy for the ITAR. So we put that as number one for those reasons. But moving down the list in terms of the critical regulatory frameworks, as you put it in your question, the next thing to think about is the US rules on foreign investment into the United States. So again, we have all of these abbreviations. The first one was ITAR. Brad and I live in this world always abbreviations. So the second one is CFIUS, CFIUS. That is Committee on Foreign Investment in the United States. Probably many of you in the group are familiar with that. So you've probably encountered that before, or you've heard of others who have. So whenever there's someone from outside the United States that is investing into the United States, under some circumstances, there is a requirement to go through review by the committee, CFIUS, before that investment can close. Sometimes, even if it's not required, it's a voluntary process, but it's voluntary in the sense that you're going to have to do it anyway, even if it's called voluntary. In the defense industry, any foreign investor that is looking to acquire a US business that's involved in defense trade almost definitely has to go through the CFIUS process, or it's highly likely to be mandatory. But if it's not mandatory, very high likelihood that you would want to do it voluntarily. And the reason for that is because the US government, through CFIUS and through the Department of the Treasury, which is in charge of CFIUS, they have the authority permanently, without any limitations period, they have permanent authority to review any foreign investment that has closed that has not been notified to them. So we, in our firm, we're aware, even 20 years later, they have come back to review old investments. So again, that's something very important to consider if you're looking to actually invest in a business here, or establish a business here. And there could be, if you're looking to establish purely a greenfield investment, totally new, no US business, you're starting it, that might be exempt. But if you're acquiring a business or if you're buying assets, then you might be subject to these rules. The next area of focus, and we get more questions about this just today. We've already had 2 client questions on it, and it's first thing in the morning, is for foreign companies that want to engage in government defense business that involves classified information, which is more advanced. What we heard from our client today is that it's more profitable. So that is attractive. This involves access to the most sensitive US government information, which is protected by classification. In order to engage in that business, a company has to go through, here's our next abbreviation, FOCI, FOCI. And what FOCI is foreign ownership, control, or influence. And a company that wants to engage in classified work has to mitigate or limit the foreign ownership, control, or influence. So often we can see foreign companies that want to benefit from classified work by setting up a US business that is limiting the foreign control of the US business. Sometimes this has to be done with the approval of the Defense Department. So with their approval, there could be a structure where there's a different board of directors in the US or other kinds of mechanisms to limit the foreign involvement. And then as we just go down the list, just to wrap up this point, those are the big ones. But to go more down the list, there are requirements in the US in relation to providing American-made goods on defense contracts. We call this domestic preference. I think maybe Turkey, many countries have the same thing. Our colleagues in the government contracts group are more experts on that. Turkey has some type of to some extent, has some kind of special status, a good status when it comes to this law. But again, we have colleagues that are more experts in this subject, but that's another area to be aware of. And the next thing is the US rules on the supply chain. So especially using anything that comes from China or using anything that comes from Russia in your supply chain to serve a defense contract is something that is highly restricted. So, for example, there are restrictions on companies that are using Huawei equipment to work on government contracts. There are restrictions on companies that use Chinese magnets, rare earth magnets, as components on aerospace projects. We've seen companies get in trouble for that. There are requirements on using certain kinds of IT or telecom equipment, like not only Huawei, but other stuff that might come from China or Russia. So these kinds of supply chain issues are very important. And then finally, just kind of the general government contracts type regulations and knowing how to comply with the regulatory aspects of selling to the US government, whether directly or through a prime contractor. So knowing those regulations is very important. So those are the frameworks. I'll just add one thing at the end to come back to the ITAR quickly, is that every company that's involved in defense trade in the US, if they're an American company or not an American company, the reason why the ITAR is so important is that it protects the release of defense technology outside the United States. And it also protects against releasing that technology even to foreign persons inside the United States. And that's a very important thing to keep in mind. And again, that can sometimes be very challenging for all companies, American or not an American company.
Mm-hmm. Thank you, Anthony. So my second question is, how early in the market entry process should companies engage with legal experts to ensure compliance with the US regulations?
So I think Brad and I have a similar view when it comes to, and Brad could put more color on this, just because, between Brad and I focus more on kind of these technical details. Brad knows all about what happens when things go wrong, right? And hopefully we're not going to let that happen to anyone here in the group. But
No.
But things can go wrong sometimes. So especially in something like aerospace and defense and government services, it really makes sense to be doing this in the beginning, because there are things that you need to do to be structured right from day one to be able to go to market. Some of them are an actual legal requirement. Like I said, the ITAR. Some of it has to do with your strategy. So if you're going to try to go after classified work in the US and you want to set up some kind of a FOCI mitigated business, that's something that takes a lot of planning to get to that point. And, that takes planning to register in the ITAR, takes planning, it's staging, making sure you have people who know how to do it, making sure you have a compliance policy. So we had a call this morning with a client. Another colleague and I had a call this morning with a client outside the US that wants to enter the defense market, and they are in the very beginning. And they've come to us, and they'll need some structuring in order to do what they want to do. So really, as soon as you decide as part of your business plan to do that, it makes sense to take the advice on it, because it takes time, and you need to build in the lead time to get to the point that you want to get to as a business.
Yeah, I'll jump in just really quickly. I've seen time and time again, I'm sure Anthony and a lot of people at our firm and, at firms that do this on a regular basis, it's so critically important to have a lawyer very early on, even though, of course, it adds some expense to these projects. The amount that it will save you in heartache later on more than makes up for it. And, some of the things you want to think about is, separate and apart from the regulatory framework that we talked about. And even in addition to what Anthony said, you may have, considerations, under other aspects, the export administration regulations, the defense federal acquisition regulations supplement, the DFARS, you're going to want to be thinking about sanctions and export controls, as it relates to the particular product or service that you are going to be engaging in. Government contracting itself in the US is quite difficult and nuanced. And, to the point earlier that, dealing with things when they come up and things have gone wrong, right? In the US, we have what's called the False Claims Act, which is often brought to bear when companies engage in contracting with the US government, but they have provided false information or inaccurate or misleading information. And that provides not only for monetary penalties, but also for potential jail sentences if you don't do it correctly. So a lot of what you want to be thinking about very early on is risk mitigation, which Anthony mentioned earlier. That's what lawyers are useful for, identifying potential regulatory hurdles, helping you develop strategies and be proactive in the things that you need to do instead of waiting around on the back foot, which not only is a legal risk, it is also, in fact, a business risk. The sooner you can get these things cleared and move forward, the better off your investment in your business activity is going to be.
So I want to ask about your experiences. What are some common legal and compliance pitfalls that foreign companies encounter when establishing a presence in the US defense industry?
So there are a lot. There are a lot that we've seen. One of the most common ones is, we'll just take it in order, actually in the same order, because there are pitfalls in a lot of these things, but especially in the couple of the things that we've referred to before. First of all, not registering under the ITAR is, to us, now that we've said it, it's an obvious pitfall, but it's not so obvious to a lot of companies. That includes American companies, by the way, that engage in defense business without going through that first step. And there is a real risk of companies that are engaging in the unregistered manufacture or export of defense articles in the United States, and just missing that first step by itself is something surprising to see, but it does happen to a lot of companies. And that is definitely a pitfall, is just not knowing that requirement exists. Another common pitfall is registering, but only ticking the box and just you're registering only for this purpose of meeting a requirement, but you don't do anything regarding compliance. So there are a lot of companies that register as ITAR companies, but they don't set up any kind of ITAR compliance policy. that includes companies that tell the government in their registration statement that they do have a compliance policy and they don't. And that, as Brad will know well, is something you should not do in terms of providing that kind of false information in a government statement. But whether you're ticking the box or not, engaging in defense trade without a compliance policy is a very, very risky thing to do. And we, again, I raise this here as a as a common pitfall, because it might sound obvious that you need to have a compliance policy, but many companies do not, and then find themselves in difficult positions as a result of that. So that is a common pitfall, which is actually not knowing when to get an export license, when to limit the access of your employees to ITAR material. Those are all common things that can come up, unfortunately. Another thing to keep in mind when it comes to the ITAR is thinking about the type of administrative requirements and resources that go into that kind of compliance. Because compared to any other kind of business in the US, I mean, doing business in the US, you have a lot of regulatory requirements no matter what. But doing that kind of business in the US requires people who know how to seek export licenses, who know how to maintain the paperwork to the requirements of the State Department, people who know when to furnish reports to the State Department that are required, people that are tracking the registration and will keep it up to date and make changes and maintain it, renew it annually. And as a matter of fact, under the ITAR, your registration statement needs to be signed by a senior officer who's a US person, and your day-to-day ITAR compliance has to be administered by somebody that we refer to as an empowered official. That's the term in the regulations. And the empowered official is required by law to be someone who's knowledgeable about the ITAR. And there's even a case where a company was penalized for having an empowered official who did not know the ITAR. So that's another pitfall, which is not planning for the resources that go into this very kind of heavy administrative set of administrative requirements that go into the ITAR and into defense trade. Another pitfall has to do with foreign investment. And, we'll get into, with all of this stuff, we can get into some specific examples a little bit later on. But another pitfall is foreign investment where an investor does not go through the CFIUS process, which that used to be something years ago that companies could escape attention for the most part by doing that. But CFIUS now has they have so many resources, so much staffing and funding to do what they do, that they are very active in monitoring foreign investment. And not filing when you're required to file or when you should file could result in CFIUS coming back later and taking action in connection with your investment, even up to forcing you to sell the company, or requiring you to mitigate your involvement in the company, or set up a different board of directors, and all kinds of stuff like that you did not plan for when you were doing the transaction prior to the signing. So not preparing for CFIUS review is very important. Or for that, and by the way, in connection with that, under the ITAR, even without CFIUS under the ITAR, you need to provide at least 60 days notice to the State Department before acquiring any ITAR company. So right then and there, you're guaranteed 60 days. But as I mentioned, most of the time when you're buying an ITAR company or investing in one, most of the time you have to go through CFIUS. So that, all of that is something to take into account. And as a matter of fact, that's another pitfall, which is in your deal, in your M&A transaction, if you're not taking this into account, you may find yourself with a much longer lead time to do your deal than you would have expected. So as I said, it's a minimum of 60 days with the ITAR as administered by the State Department. But with CFIUS, it's 3 to 6 months between signing and closing. So that we have seen companies get taken by surprise when it comes to that, and that's not good for the deal. It's not good for the business relationship, and it could lead to it being more challenging to go through the process if you didn't expect to do it. So that's another pitfall in this area. Brad, I don't know if you have more to layer on to that.
Yeah, I mean, really just at a very basic level, what I run into the most when we're dealing, with the fallout when it's not done properly is really just poor record keeping, right? The books and records aspects of dealing with these rules and regulations is so very important. And, you really have to pay attention to creating and then maintaining proper records of your compliance efforts and what you're doing in relation to all of these regulations and the way that you are structuring your deals. Because that ultimately, number one, it provides proof that you're doing what you're supposed to do. Obviously, many of these things require a very formalistic approach with the U.S. government, but for those things that you are expected to do within your company to maintain compliance with the rules and regulations, making sure that you document that is the most important thing that you can do. I can tell you that the easiest way for the government to come in and cause you problems is if your paperwork is not in order or that you are putting information that is either misleading or untrue, or could be perceived to be misleading or untrue because you don't have proof that things were actually done. That's where you get into big issues. And in these instances where you're dealing with defense and national security and very important aspects related to things that the U.S. government in particular are very concerned about, minor oversights of the regulatory requirements can lead to significant issues. And so you've really got to dot your I's and cross your T's with all of this stuff.
Mm-hmm. Thank you, guys. And I want to ask about the CFIUS. We have seen increased scrutiny over foreign direct investment, especially in defense-related areas. So how can companies manage CFIUS reviews to avoid delays or rejections?
So some of that, it's another good question. Some of that has to do with pre-positioning yourself as a company before you even undertake to invest in the U.S. So what do I mean by pre-positioning? Is that when CFIUS is conducting a review of a foreign investor, number one, they're looking at where is the investor domiciled and what is the nationality of the people who are in control, right? And we all kind of know, we all understand that. The U.S. government will look at national security threats in connection with the nationality of the company, the nationality of the control persons. So, for example, a Chinese company or Chinese-controlled company would never be allowed to invest in the defense industry in the United States. Never. We know that. That's obvious. But what is less obvious is that the connections, the third-party connections that a company has around the world is also something that CFIUS looks at. So if a foreign investor, they could be from a totally friendly, the closest ally of the United States, whichever one you want to name. But if this is a company that has close relationships with China, with Russia, and that could be supply relationships, it could be customer relationships, it could be the having subsidiaries in some of these locations. That's something that CFIUS is going to take into account, because those connections, which have nothing to do with the deal, they have nothing to do with the investment, but those kinds of connections carry with it national security implications that are relevant to the national security review that the CFIUS is carrying out, because they're thinking about things like, will the foreign investor buy a US company, take their technology and send it to China? Or are they going to share it with their subsidiary in China? Or this is a company that uses Chinese suppliers. Are they going to start to put Chinese equipment into defense deals, right? They're always thinking of the worst case scenario. And to prepare for that in a CFIUS context, we want to be one step ahead of that kind of consideration of worst case scenarios. We want to be prepared as a company or an investor that's going to invest, particularly in the defense industry in the United States, to be ready. And to be ready means that you really are free of these kinds of national security issues. The other thing, which can be difficult, is to be ready to be transparent. Because the CFIUS process is difficult and it asks for a lot of information. It could be information that the company has never shared with anyone, especially not a government regulator, especially not a government regulator in another country. But it is a fairly exhaustive review process that involves letting go of some confidential information. So to be prepared to be transparent is important. And that sometimes or often that will be outcome determinative as to whether you can close a transaction or not. Another aspect of CFIUS review is accounting for the possibility that you are going to be expected to mitigate the national security risk in the transaction, which I think is something that for the first time could catch investors by surprise. Like, for example, there might be, CFIUS may withhold approval of the investment until the foreign investor agrees to certain conditions before they're going to approve it. So these could be conditions like you have to limit the governance of the people in the board of directors. You have to limit their access to technical data. That's very common, is that the foreign investor cannot obtain any technical data. There might be requirements to supply the US government at a certain amount. So if you're investing in a company that is a supplier to the US government, CFIUS may require continued uninterrupted supply for a number of years to the US government, regardless of your business plan. They could require things like, guaranteeing that some of your foreign subsidiaries do not participate in a transaction, or that they don't participate in any government business. So just preparing yourself for that kind of the possibility of mitigation, which is becoming fairly common, is, I think, something that can take companies by surprise for the first time. And it doesn't have to be the first time. It could be companies that have gone through it many times that might expect that they don't have to do this, and then suddenly they're being asked to do it. And being prepared for that is important. And as a matter of fact, that becomes part of the commercial negotiation in the deal, where the seller may want you as the buyer to commit to do the deal no matter what. And that could be difficult, and not everyone wants to do that. Not everyone wants to sign up to agree to whatever the US government tells them to do in order to do their transaction. So part of your negotiation is, when do I get to say I'm out and I'm not going to do the deal? So that these are, those are, some things to think about. And I guess, otherwise, how can a company manage CFIUS reviews to avoid delays or rejections? Be prepared for the effort that's involved, which is unlike many regulatory efforts under US law. So I think there's a perception, we run into this very often. It's common. There's a perception that getting a CFIUS approval is a relatively minor undertaking, or that it's just a paperwork requirement. It's not very intense. It's fairly intense, and it's resource intensive. It takes time. It takes a lot of your time to do it. It takes a lot of your advisor's time to do it. And preparing for that effort and the resource and the time is very important, because in order to get the deal done according to the CFIUS timeline, you have to answer their questions quickly, and they're going to have extensive questions that go very deep, and you'll be expected to answer them on time. And again, as I said, when you add all of this up, it can take 3 to 6 months. And that, especially in defense, it's probably closer to, say, 4 or 5, sometimes 6 months. So these are things, very often companies get approvals at the end of this. There are happy endings to these stories. I don't want you to think it's all like very difficult and nothing good happens. Most of the time, good things happen, but it's a challenging process to go through to get to the other side of that.
Shafik, do you want to pause and I'll read some of these questions, and maybe Anthony or I can field them?
Please,
all right.
Please.
I'll let me read the first one. So it says, we won the new NATO tender for secure communication. In this project, we are developing a secure SATCOM modem based on STANIG. Are there some facilitating methods for making business or sell the same or similar products to the US for those NATO compliant products? And it goes on to say, or could there be special advantages in collaborating with US companies to customize those products? Caveat to all of this, or any answers that we give are obviously very preliminary without any details, but we'll do the best we can to field them. Anthony, thoughts on that?
Yeah, so I guess one question would be, what access can you get to the information from the customer regarding how they want it to be customized, right? Which is, in other words, is this the kind of market, or is this the kind of scenario where typically you're going to be expected to go through a US company to do it? Or will you have access to the end user who can give you that kind of information? I think that in either case, you're going to be expected, in order to do that customization, probably somebody on the US side is going to need ITAR permission to do that in the US. So what do I mean by that? If you're a company outside the US and you're ready to supply into the United States, there's going to be someone in the US who has to send you technical data in order for that to happen. Or you're going to be sending them technical data, or you're going to send them a prototype or a sample, and it's going to pass back and forth. And there needs to be ITAR authorization that covers all of that back and forth. it might be the case that you could have direct access to, let's say, the end user or to a prime contractor that's willing to work with you directly to do the customization work. They probably will expect you, my guess, is that they probably will expect you to sign up to an ITAR agreement in order to engage in that activity. So what do we mean by ITAR agreement? Is under the ITAR, like I mentioned, for any kind of technical data, in this case, it would be your technical data relating to the customization. So the US customer or the US end user, they need to tell you how to customize the product. And in order to do that, they have to send you technical information. They need permission. Probably the way they will get that permission is by asking you to enter into a technical assistance agreement, which is called TAA. And that is a type of permission under the ITAR where the company outside the United States and the company inside the United States agree to all of these ITAR requirements. They call it an agreement, but it's not, you don't negotiate it. The wording comes from the government. And the two sides sign up to this, and that's what governs how you can exchange the information back and forth. So that's another element to be prepared for, which is signing up to this ITAR agreement to be prepared to safeguard the technical material data, the technical data when you receive it, and operating in compliance with the ITAR. So, whether you can customize and go directly to the customer, or whether there's an advantage in collaborating with a US company, that's kind of a business question in terms of how you go to market, the connections that you have, what the customer or the end, what they prefer. But in either case, you'll have this, highly likely you would have this kind of ITAR agreement that would govern how to exchange this technical information.
Thanks, Anthony. There are 3 more questions on the Q&A boxes.
Yeah.
You stated there are restrictions on IT and telecommunications equipment. Does this mean restrictions on inclusion in a product of specific Chinese or Russian telecommunications equipment, or does it include the use of such telecommunications equipment in, for example, the design department of the foreign firm?
Yeah. So this is a very complex area. I'll start by saying that. And what I will add to that is that we have other people in the firm that specialize exactly on this subject, because it's more, so part of this is a government contract regulation. Part of it is a international trade regulation. Let me explain what I mean. Number one, in the government contracts, there is a requirement in connection with not using certain kinds of Chinese telecom equipment in performing your government contract. Specifically equipment coming from Huawei, ZTE, some other specialized companies, so some other specified companies, which their equipment cannot have any role in fulfilling a US government contract. Number two, there are prohibitions in connection with even using this kind of technology on your own outside of performing the contract. If you want a contract with the US government, there are limitations on your ability to use that kind of equipment on your own time, not connected with the contract. It's not the same as the first prohibition. It's more limited, but it does exist. Another thing to add to that is, I know we're talking about telecom, and we're going to come back to that in 1 second, but just before we do that, there's also prohibitions in some cases on using material. that originate particularly in China. And we've seen companies in the US get in trouble for this. So, for example, using Chinese rare earth magnets for use in building a US fighter jet is something that led to a scandal in the US and reputational damage for companies that were involved in that. And that's another example of a supply chain restriction. Now, let's come back to telecom, because that was the real question. So what I was referring to with speaking about Huawei and all of that, those are requirements that exist under the government contracting federal acquisition regulation rules. These are the rules that govern your conduct as a company that is a supplier to the US government. That governs what kind of equipment you can use. Separate from that and apart from that, and this is becoming a big area in the US, is there are other regulations that are connected with the technology supply chain. These are known as we have another abbreviation, ICTS, Information and Communications Technology and Services Regulations, which are administered by the Commerce Department. These regulations have to do with any kind of technology, IT, telecom, network infrastructure, connected applications, Internet of Things, robotics, artificial intelligence, emerging technologies, networking, home networking, drones, any of those kinds of technologies. Critical infrastructure is another one. Any technologies in those applications that have a connection with China or Russia. So they were developed in China or Russia. They were made by a company in one of those countries. They were made outside those countries, but the owner is Chinese or Russian. Any of those technologies that have connections back with those companies, if they're going to be used in the United States, the Commerce Department has the authority to review the use of that technology and to either order mitigation or to prohibit it completely. So let me give you some examples. The reason why I say it's becoming a big area is because only in the last several months have they started to do anything with these rules. So a few months ago, the Commerce Department issued a rule that prohibited all use in the United States of Kaspersky Lab cybersecurity and antivirus software on the basis that Kaspersky Lab, which is a very well-known Russian-owned cybersecurity company and has done business in the US for a long time, but they did that on the grounds that since they're a Russian company and there's a connection with government business and there's a connection with critical infrastructure and your home networking, that they're going to prohibit all use of the antivirus software, all use of the cybersecurity software, basically kick them out of the United States. That's one thing. Another example, just again from last month, is now the Commerce Department is reviewing automotive technology that might be originating in China or in Russia. And they have proposed to now ban cars, importing cars into the US if they have Chinese technology, or banning the import of the actual equipment that enables the connectivity in your automobile if it originates in China or from a Chinese-owned company outside of China. So that, there's a lot of talk about this right now in connection with, is there any kind of equipment that's in the supply chain, particularly for defense or aerospace or critical infrastructure? Is there anything in the supply chain that poses a threat? And I would think about that in terms of, are you are you actually putting any of that equipment into what you're giving to the government? Or apart from that, are you using any of that kind of equipment or services to do the work? Because in either case, there are risk points to look at before you go far down the road of doing government business, because what we've seen is if it goes wrong, the government may need to rip out, they call it rip and replace. They may need to rip and replace that kind of content. It's very bad publicity. So, definitely that's a risky area. And again, even something like that factors into CFIUS if you want to invest in the US. So very risky area, something to really think about and plan for in advance before getting into defense business in the US.
There is a question about a concern of the confidentiality of the CFIUS review, and the question is how secure is CFIUS review? That is, if my potential foreign partner reveals strategic information to the CFIUS review, can the partner be confident that the information will remain confidential?
So some things on this. Number one, CFIUS itself will keep it confidential. So that, this is a very important point because I think we need to identify what is confidential and what is not. The information that you provide in your filing to CFIUS, the information that you're giving to the government, they protect that, the government protects that from disclosure. So it is exempt from the US Freedom of Information Act. It's exempt from disclosure under US transparency laws as far as the government goes. However, if you're involved, for example, in a transaction with a publicly traded company, it might be the case that the CFIUS, the existence of the CFIUS review on your transaction is something that has to be disclosed to the Securities Exchange Commission. Or there could be other ways where the CFIUS information, not the information you're providing, but the fact that there is a review and that there is a transaction under review, that type of information could come out. Now, unless there's a legal requirement like securities filings, companies may try to manage that through confidentiality requirements in the purchase agreement. But generally speaking, the information you're providing through the process is considered to be extremely sensitive information that the US government has not only are they not allowed to release it, they have an interest in not releasing it because they want companies to be able to come to them with these reviews. So is it possible that the information may come out that you are under review? Maybe, unless you're able to protect that. But the actual CFIUS information itself about your business, your investors, your company, that information would be, if that were to be released, something would have gone very, very wrong. So that I'm not even aware of that happening. So that information is really considered to be very much exempt from disclosure.
Mm-hmm. The next question from the same audience, that is your recommendation then that a company not attempt CFIUS review on its own without US counsel?
Definitely. And Brad and I were pretty transparent. We don't try to, we'll tell you when counsel's not required, right? But for a CFIUS review, without question, you need US counsel to manage it. Because especially the regulations themselves are very complex, and even apart from what is in the regulations publicly, CFIUS practice is kind of unique. Well, there are a lot of things like this, but especially CFIUS is unique because there's a lot of unwritten law. There's a lot of unwritten practice about what you're expected to do. And that's where counsel could be really helpful, is knowing here in DC what the practice is, what the expectations are, how to answer the questions, which are very detailed, how to stay on time, how to negotiate with the government if you're involved in a mitigation situation. And they're going to expect that. CFIUS will expect it. And as a matter of fact, an investor probably would be taken less serious without counsel.
I think there is one more in the last question. Based on what has been said, is there any restriction on special forgings or castings typically for aero engines, for example, made by a Chinese company, either in China or in another country?
Yeah, there could be. So that, that kind of invokes a couple of different things. So I'm assuming the question means using those engines or the castings for the engines in connection with a U.S. aerospace contract, right? So the short answer is there could be, not necessarily, but there could be restrictions in connection with that, and that's something that would have to be looked at closely, whether that implicates supply chain rules or requirements that are in the contract itself. Or one other thing, which is worth mentioning, is US rules under the ITAR. So the ITAR they focus on exports of ITAR material and ITAR munitions. The ITAR also focus on brokering of defense articles. So if you're a US person, if you have a US person in your organization, or on the other side, you might be doing business with a US person, it is prohibited to broker Chinese defense articles. A US person cannot broker Chinese defense articles in a defense transaction. So somewhere in there is a limitation on what someone is able to do. Whether that actually leads to a yes or no here is something that would have to be looked at in more detail. But you're right to ask the question, which is, if you have that kind of a situation for a US aero contract, it's something you want to review from a regulatory perspective before you commit to that supply arrangement.
So it's almost, the time is on, and thank you very much, gentlemen. This brings us to the end of our webinar. I would like to sincerely thank both of our speakers, Antonio Rappa and Brad Henry, for their valuable insights. If anyone in the audience has further questions or would like to follow up, please feel free to reach us. Thank you all for attending, and we look forward to seeing you at our next event.
Thank you, Shafik. Thank you, everyone.